Welcome to LexIcon, your visual guide to public international law. Before we start our lecture today, think of this. French law applies to natural and legal persons in France, that's quite clear. And by analogy, Romanian law, for example, applies to natural and legal persons in Romania. Question that is more relevant for us is, what about international law? Therefore, the topic for today will be subjects of international law. Let's first define the notion. What is a subject of international law? There is no uniform definition, but the most common one is that a subject of international law is a person or entity capable of possessing international rights and duties and having capacity to maintain its rights by bringing international claims. If we divide that definition into elements, first one is international rights, second, international duties, and these two together form a notion of legal personality. And then the third is the capacity to bring international claims. And while the first two elements are relatively clear, we still have to establish what is that capacity to bring international claims. The International Court of Justice in the 1949 case, Reparation of Injuries Suffered in the Service of the United Nations, provided that the competence to bring an international claim is the capacity to resort to the customary methods recognized by international law for the establishment, the preservation, and the settlement of claims. And a couple of examples that the court provides are protest, request for an inquiry, negotiation, as well as arbitration and litigation. But let's now get back to our initial question. What are the subjects of international law? Original and primary subjects of international law are sovereign states. Why is that? Because they satisfy all criteria. They have international legal personality, international rights and duties, and they are capable of bringing international claims. But let me give you some examples. So the states are recognized as legal entities. They have international rights, such as the right to self-defense. They have international obligations, such as the duty to respect sovereignty of other states. And one state can bring a claim against another state, for example, at the International Court of Justice. There are state subjects, but then there are also non-state subjects of international law, but the list is not set. It may include international organizations, individuals, national liberation movements, revolutionary groups, multinational corporations, NGOs, and so on. Let's examine them one by one. The International Court of Justice, in the same 1949 case, Reparation of Injuries, said about whether the United Nations is a subject of international law the following. The organization is an international person. That is not the same thing as saying that it is a state, or that its legal personality and rights and duties are the same as those of a state. It is a subject of international law and capable of possessing international rights and duties, and it has capacity to maintain its rights by bringing international claims. International organizations are recognized as legal entities. Their international rights and obligations can be found in treaties that are signed by international organizations, and they can bring international claims, and international claims can also be brought against them. What about individuals? During the 20th century, individuals become more visible in international law. They become central focus of human rights law as a separate discipline, individual criminal responsibility for grave violations of international law, war crimes, crimes against humanity is being introduced, and individuals finally get direct access to courts. Does this mean that individuals are subjects of international law? Well, in 1949, the International Law Commission, a body of the United Nations, has produced a survey of international law, and the following can be found there. There is nothing in international law to prevent individuals from acquiring directly rights under a treaty. The obligations of international law bind individuals directly regardless of the law of their state. So there are international rights and duties present in the international legal personality. A number of international instruments have recognized the procedural capacity of the individual, meaning that individuals can turn to courts. Let's look closer. So individuals definitely have international rights. For example, human rights, rights to life, right to fair trial. They have international duties. For example, a military during combat has a duty to disobey a manifestly unlawful order of the superior. And individuals are recognized holders of international rights and duties, meaning that they have international legal personality. Individuals also have the capacity to bring international claims. For example, a person can turn to the European Court of Human Rights. Now, what about groups of individuals? If individuals are subjects of international law, then maybe groups of individuals such as national liberation movements, revolutionary groups, and other non-state groups are also subjects of international law. But here, when we take our checklist, we're not that sure whether such groups satisfy all criteria. And here it is relevant to look at something that the International Law Commission has provided. The international legal personality of the United Nations and of other international organizations call for a redefinition of the traditional rule. Legal personality is no longer a postulate of scientific doctrine. It is accompanied by a recognized contractual capacity in the international sphere. So maybe the old checklist is not that relevant anymore, and we should bring a new criterion such as the capacity to enter into international relations. But let's proceed. There are certain non-state subjects that gained more recognition as subjects of international law, such as international organizations, individuals, and so on. And there are other subjects, non-state subjects, where the scholars are still debating whether they are indeed subjects of international law, such as NGOs, multinational corporations, and terrorist groups. Let's take some of them. NGOs are a way for individuals to communicate with governments through non-governmental channels, and certain powerful NGOs indeed have the capacity to enter into international relations and have an effect on lawmaking. Multinational corporations are also quite relevant because large companies today play a very important role on the international arena, and large businesses are encouraged to adopt more responsible and sustainable policies. Thus, we can come to the conclusion that non-governmental organizations and multinational corporations, although they're not yet officially recognized as subjects of international law, indeed play a very important role in international law. That was it for today. I thank you for your attention, and I hope this video has been useful, and I see you very soon.